Good morning. Thank you very much for joining us. Welcome back. This is European Law Interviews, a program sponsored by the Jean Monnet Chair, which is part of the European Commission Training and Education Program. We have the great opportunity today to interview Professor Nicolas de Sadeleer. Good morning, Professor.
Hello.
He is Professor in EU Law at Université Saint-Louis Brussels and Université Catholique de Louvain. Today we will start a new series on human rights. We will start with the first interview on the Charter and secondary law. Watching the news, you can see that environmental disasters, pollution and significant deterioration of the environment have a huge impact on human beings. Human rights and environmental rights have developed in parallel. However, today they tend to cross more and more. There is an intersection for those rights. At international level, there has been a lot of discussion on it, but not really at EU level. The aim of today's interview is to focus on developments in European law on the environment and human rights. Before the Treaty of Lisbon, there was no such thing as a list of fundamental rights within EU law. Hopefully, with the entry into force of the Treaty of Lisbon and the adoption of the Charter of Fundamental Rights, we changed of logic. Before, the EU was only about economical objectives and the internal market. Now there is a new turn and new elements. This Charter of Fundamental Rights has the same value as the treaties, as explained in Article 6.1 TEU. We will focus today on Article 37 of the Charter that I am going to read. A high level of environmental protection and the improvement of the quality of the environment must be integrated into the policies of the Union and ensured in accordance with the principle of sustainable development. The first part of today's interview will be devoted to the Charter of Fundamental Rights and especially to Article 37. Professor, my first question is about the scope of Article 37. Does this provision confer any right in the sense of an individual entitlement guarantee to the victims of pollution?
Not at all. That provision specifies any beneficiary to such a right. So it cannot confer any right in the sense of an individual entitlement. Accordingly, it cannot be placed upon equal footing with other provisions of the Charter proclaiming specific fundamental rights. So that provision has been drafted much more as a policy principle than genuine fundamental right.
And which institutions are in charge of the implementation of Article 37?
By virtue of Article 52, paragraph 5 of the Charter, the EU institutions, as well as the agencies and the bodies of the EU, may implement this principle. In addition, member state authorities may also implement Article 37 principle with respect to the areas of EU law that are likely to flesh out into concrete national provisions. Paragraph 5 of Article 52 is adding to that the principles of the charters are judicially cognizable only with respect to the interpretation of EU law or national law implementing EU law, and in ruling on the validity or in reviewing the validity of these EU acts and national acts. Accordingly, Article 37, as any other principles enshrined in the Charter, cannot give rise to a direct claim for positive action. Such a principle can act merely as an interpretative principle.
Okay, thank you. And so the legal effects of such a provision are quite weak, but they are not absent. So my next question is the following. Can the courts ignore Article 37?
No, by virtue of the paragraph 5 of Article 52, the court have to take into consideration Article 37 with respect to the interpretation to be given to directives or regulations or decisions dealing with environmental protection, as well as with respect to the national provisions fleshing out into domestic law these EU obligations.
Okay, thank you. And as Article 37 is quite vague and flexible in terms, is it easy for the court to review such a principle, such an article?
Whether a claim based upon the violation of Article 37 will be successful before a national court or the Court of Justice of the European Union remains to be seen. Why? For three reasons. Article 37 contains three components that are extremely broadly framed. Firstly, the principle is aiming at enhancing sustainable development, which is a very broad concept, as we already discussed in previous interview. Secondly, environmental protection has to be integrated into the different actions and policies carried out by the EU institutions or the member states with respect to EU competences. The level of integration has not been defined and is likely to differ from one policy to another one. So the level of integration of environmental concern into the transport policy might differ from that level of integration into the common agricultural policy. Thirdly, what must be integrated into the different actions and policies is a high level of protection. That concept is a relative concept. As a matter of course, there are constant disagreement regarding to the appropriate level to protect our environment. Given that the three components are so broad, an action for nullification of an act in breach of Article 37 might not be so successful.
Okay, thank you, Professor. We will now move to the second part of the interview devoted to constitutional law. So, in primary law, there is no constitutional right to environmental protection. However, Article 6.3 states that fundamental rights result from constitutional traditions common to member states.
Of course.
My first question will be, are all these national constitutional provisions drafted along the same lines?
No, some provisions claim a healthy environment, a suitable environment, an environmental adequate for the development of the personality, and so on and so on. So there are huge differences as a matter of drafting each of these provisions. Of importance is to differentiate two categories of provisions. On the one hand, some constitutional lawyers have been drafting a genuine right to environmental protection, such as the Netherlands, Norway, Belgium, whereas on the other hand, other constitutional lawyers have been drafting a duty for state authorities to improve the quality of the environment or merely to protect the environment.
Okay, thank you. And do you have a concrete example for people watching us?
Yes, if I may, I would like to read the Article 36 of the Constitution of Ukraine of 28 June 1996. I know that Ukraine is not likely to become a member state in the coming years, but that provision is of interest to ensure ecological safety and to maintain the ecological balance on the territory of Ukraine, to overcome the consequences of the Chernobyl catastrophe, a catastrophe of global scale, and to preserve the gene pool of the Ukrainian people, it is the duty of the state to protect the environment.
Okay, thank you. And what is the added value of this constitutional provision?
Yeah, as a matter of fact, there is an added value. Firstly, environmental issues are elevated as a new value within the constitutional legal order. Environmental values are standing at the apex of the national or the domestic legal order. Such a value is standing above mere political choices that are likely to be modified at will by the lawmaker or the government. Secondly, such constitutional rights are not deprived of legal effects. They are taking precedence over inferior norms such as legislative acts or executive acts or even administrative acts. Thirdly, the recognition of a right to environmental protection at constitutional level is likely to reinforce the constitutionality of environmental legislation or environmental secondary legislation that cannot longer be trumped by fundamental rights such as the right to property or the right to economic development. Of importance is to stress that the recognition at constitutional level of environmental rights is departing from the hand-off attitude that has been characterized the first generation of human rights. Such provisions are calling for affirmative actions on behalf of the state authorities to reinforce the level of environmental protection. These constitutional rights straddle second generation economic, social and cultural rights and third generation solidarity rights.
Okay, and the last question of this part would be related to member states. Could they rely on these constitutional provisions in order to derogate from fundamental economic freedoms?
Bearing in mind the Schmidt-Berger case that related to the possibility for Austrian demonstrators to block a highway during 24 hours, a highway in the Inn Valley throughout Austria, and impeding the flowing of goods from Germany to Italy or from Italy to Germany, it appears that the Court of Justice is aware that constitutional values such as the freedom of demonstration, the freedom of expression, is likely to restrict, albeit proportionally, the free movement of goods principle. With respect to the freedom of services, in Omega, the Court of Justice took the view that the constitutional German right to human dignity was likely to restrict such a freedom.
Thank you very much. We will now move to a third part of the interview on EU secondary law. So the provisions of the treaty relating to environment are quite broadly framed, so it's not always very useful. However, there are standards and hundreds of standards of environmental protections deriving from the directives, and we have hundreds and hundreds of directives on the topic. My question is then, do citizens of the Union today enjoy a right to a clean environment?
As you are rightly pointing out, EU environmental secondary law is rather complex. It is reckoning upon 300 directives, 50 regulations, a huge amount of specific decisions. Of importance is to stress that there is a procedural approach. Member states are called on under these arrangements to carry out surveillance, control, implement programs, plans, provide for proper enforcement. As a matter of fact, the vast majority of these directives and regulations and decisions does not provide for a specific environmental right. Needless to say, several air pollution directives might confer indirectly to litigants enforcement rights. So whenever the exceeding of air limit values is likely to endanger the individuals concerned, these individuals must be in a position to rely upon the EU mandatory standards thresholds before the national jurisdictions. So though these EU standards are not precise enough, are not unconditional enough to entail direct effect, nonetheless, the individuals are likely to reckon upon them to contend with the national regulatory practice before the national courts. And with respect to this directive, of importance is to stress that they never proclaim such an environmental right.
Okay, so conferring implicitly rights to persons likely to be affected by illegal pollution is not enough, because the environment is not only about health impairment, it's about the ozone layer, climate change, and many other things, disasters. So don't you think that more favorable standing conditions are likely to flow from directives that are not restricted to human health?
Yeah, as a matter of course, environmental policy does encompass a wide array of subject areas, ranging from GMOs to listed installations, ranging from nature protection to the control of the impairment of chemical substances. With respect to the directive on impact assessment, the former 85/337 directive, the Court of Justice has been taking the view in Christopher Miller and in Lister judgments that standing rights were flowing from the procedural obligations set out in such a directive. And that was linked to the principle of effectiveness, or le principe de l'effet utile de la directive. Individuals may rely on procedural provisions to contend with procedural national arrangements contrary to that directive before the national courts. And when these cases were adjudicated, the EIA directive did not proclaim any litigation right. By the same token, under the Habitats Directive 92/46, the Court of Justice took the view in the Wadenzee case, it's a bird protection case in northern Netherlands, that the applicants could rely upon the procedural provisions of Article 6 of that directive to contend with the ministerial practice of the Dutch authorities. Though in the Habitats Directive there is no such litigation rights being enshrined.
Okay, thank you very much, Professor. This is the end of our first interview on human rights. So today we discussed a lot Article 37 of the Charter of Fundamental Rights. We start the interview with a section on this Charter of Fundamental Rights, dealing with the scope of ambit of Article 37, the role of the institutions, the legal effects, and insisting on the fact that courts cannot ignore Article 37. Then we moved on constitutional law and gave several examples of the use of the provision. And finally, we just discussed briefly EU secondary law and the impact of more precise directives on the right to environmental protection. Thank you very much for watching us and see you next time.